All right, let's talk about the HOA. You know, for some people, it's the guardian of property values. For others, well, it's a source of endless neighborhood drama. Today, we're going to dig into a real-life legal fight that all started with a simple fear of flooding and spiraled into this two-part court showdown.
So who are the players? In one corner, we've got John A. Sellers. He's a homeowner, and he's getting pretty worried. And in the other corner, you have the Rancho Madera Condominium Association, the HOA. Yeah, it's that classic homeowner versus the board setup, but trust me, as we're about to see, the details here are anything but ordinary.
I mean, really, what happens when you sue your HOA over a few plants and a bit of chicken wire? It sounds kind of trivial, right? But this whole case hinges on that exact question. It's a dispute that really forces us to look at not just what an HOA can do, but what it must do. So let's get into the story.
Okay, so here's our roadmap. We'll start with the homeowner's flood fear, walk through the first hearing and its verdict, see why he got a second chance, and then cover the final decision and, most importantly, the key takeaway from all of this.
So every story has a beginning, right? This one starts in a little 3-foot-wide drainage channel. It runs behind a row of condominiums out in Cave Creek, Arizona. You know, just a small space that was about to become a huge legal battlefield.
And at the very heart of this whole fight is a single sentence from the HOA's governing documents, the CC&Rs. It seems totally crystal clear. Homeowners are responsible for keeping this drainage area clear so water can flow. This one rule, it becomes the entire foundation for the whole case.
So what was actually causing all this trouble? Well, according to the homeowner, John Sellers, it was a mix of stuff. We're talking large succulents, shrubs, cacti, and, this is the weird part, chicken wire, which, is probably just there to keep a small dog from wandering off. But to him, this wasn't just landscaping, it was a disaster waiting to happen. His big fear was pretty simple. If a heavy rain comes, all that debris is going to get caught on the plants and the wire, and it's going to create a dam. And that dam would send floodwater right into his home, Unit 12. Seems like a legitimate concern, right? So he took that concern to his HOA, and when he felt like they didn't do anything, he filed a petition.
And that brings us to the first hearing. This is where both sides laid all their cards on the table, in front of an administrative law judge.
Okay, so Sellers comes in with photos of the plats and the wire, and he's arguing about the potential for a flood. But the HOA, they come back with a really powerful fact. This community has been here since 2012. It even weathered a massive 100-year storm, and through all of that, Sellers' unit had never, ever flooded, not even once.
And then came the twist, a total bombshell. An email gets submitted as evidence, and it's from the petitioner's own wife, written to him and the HOA board. In it, she calls the whole thing nonsense and literally tells him to stop making something out of nothing. Wow, you can just imagine how that landed in the courtroom.
So, with that bombshell email now officially in evidence, the judge made her decision. Now, to really get her ruling, you got to understand this legal term, preponderance of the evidence. It's the standard for most civil cases. All it really means is that the person making the claim, in this case, Sellers, has to prove that his version of events is more than 50% likely to be true. It's not beyond a reasonable doubt like in a criminal case, it's just more likely than not.
And here is where that legal standard really kicks in. The judge actually agreed, yeah, the plants and the wire were there, but Sellers just couldn't prove they were actually a problem. He showed a potential risk, sure, but he failed to show it was a probable one, and that meant he didn't meet that preponderance of the evidence standard.
The judge really hammered this point home, pointing to the undisputed fact that the drainage system had worked perfectly for years. History was totally on the HOA's side. So, case closed. Or was it?
Just when it seemed like the whole saga of the clogged ditch was finally over, the story takes another turn. Nope, this was not the end of the road for John Sellers.
And you have to be asking yourself, how does that even happen? A judge makes a really clear ruling based on all the evidence, and yet the case comes back? What could possibly have justified a total do-over?
Well, it turns out there's a process for this. Sellers filed a formal request for a rehearing. He claimed there were legal errors and irregularities in that first proceeding, and in what was a pretty surprising move, the commissioner of the Department of Real Estate actually agreed and granted him a brand new hearing. And this led to round 2, but this time Sellers came back armed with a completely different and, honestly, a much more sophisticated legal argument.
His new strategy was actually pretty brilliant. He argued that, yeah, the CC&Rs give the HOA the right to enforce the rules, but he claimed when it comes to big issues like safety and protecting property values, that right actually transforms into a duty. It becomes an obligation for them to act.
And this, right here, is what the entire case boiled down to. The CC&Rs clearly state the HOA has the right to enforce. They also state the HOA has an obligation to, say, repair damage after it happens. So the big question for the new judge was this: does the HOA have an obligation to act before any damage occurs?
And the final ruling was totally definitive. The judge looked at the plain language of the contract, the words on the page, and found that while the HOA had the option to enforce the rule about clearing debris, there was nothing in that document that obligated them to do so. The specific words of the contract mattered most. End of story.
So, after 2 hearings, multiple judges, and months of legal battles over some plants and chicken wire, what have we learned? And more importantly, why should this matter to you whether you live in an HOA or not?
Let's just boil this entire legal saga down to one single crucial lesson.
It's simply this: words have power, especially in a contract. What you may do is fundamentally different from what you must do. This whole case is just a powerful reminder that in any legal agreement, that distinction between a right and an obligation can make all the difference in the world. So yeah, read the fine print. It really, really matters.